I guess it's time to start. So I'm Sean Rehaag. I'm a faculty member at Osgoode Hall Law School. I'm also the director of Osgoode's Refugee Law Laboratory. And before that, I spent some time as the academic director at a legal clinic, a poverty law clinic connected with Osgoode. I do quantitative empirical work. I also do a lot of work on access to justice and poverty. And so I'm particularly excited for the papers that we're going to hear about today that deal with access to justice and income. You all have the bios for our speakers, so I'm not going to go through them in any detail. I would invite you to take a look online. All of the speakers have been told that we are going to be strict with timing today, that they're going to speak for about 10 to 12 minutes each, and we're trying to have lots of time for conversation at the end. So our first speaker today is Claire Johnson Raba, who is an assistant professor of law at the University of Illinois, Chicago. Over to you.
So get the slides up. Are the slides up? There we are. Okay, great. So thank you so much for the organizers of this forum. I've learned so much over the last few days and met so many fascinating people doing incredible work in access to justice. And thank you all for being here. I'm Claire Johnson Raba. I'm an assistant professor of law at the University of Illinois, Chicago School of Law. I'm also a co-principal investigator with the Debt Collection Lab, an interdisciplinary lab at Princeton University that engages in empirical research on debt and debt collection. We use data to tell the stories of people and communities impacted by debt. The project I'm going to talk about today was supported and funded in part by the Pew Charitable Trusts. You can find the policy reports I'm going to talk about today on our research page at thedebtcollectionlab.org/research. My non-presenting co-authors today are Dalia Jimenez of UC Irvine and Professors Prasad Krishnamurthy, Manisha Padi, and Abhiya Neha of UC Berkeley. Unlike my co-panelist Juliet, I'm not an economist, although three of my co-authors are. So today I'm going to share findings from a study that we've conducted over the past year. So debt collection is an enduring feature in American courts. For 250 years, debt collectors and debt collection has happened through legal processes in a way in which merchants, moneylenders, and businesses have engaged in the collection of debts from consumers. And these cases are all filed in state courts, which all maintain their data in different ways. Cases are not often classified as debt claims, and one of the goals of the Debt Collection Lab is to collect this data, normalize it, clean it, and create data standards for the 50 states and then the 50 to 100 counties that collect this data for the cases that run through the various counties. When we collect data from state courts, some of our primary data standards for identifying debt collection cases are cases from a business suing a person that originated as a contract claim, not a tort claim, or a statutory claim for money owed. And these are generally a volume practice. We identify our volume filers as those businesses that file more than 20 cases per year. And then we classify those plaintiffs as either original creditors, the company with whom the consumer entered into contract, or third-party debt collectors, those who are assigned or buy a debt for collection. So research over the last 15 years by various scholars in various states in the US have shown serious abuses, robo-signing, lack of evidence of assignment, and courts rubber stamping requests for entry of default against consumers who do not respond to the lawsuit. So state legislatures and courts have responded to concerns by consumer advocates by passing legislation or rules designed to ensure that debt collectors attached evidence that show they own a consumer debt when they file a lawsuit or when they requested entry of default or both. So this study examines those changes in 3 states, Texas, Connecticut, and California, each of which had a statewide change that impacted third-party debt collectors, but not original creditors, all at about the same time. Texas and California's changes were effective in 2013, and Connecticut in 2014. So we call these debt documentation reforms. And because we have 2 groups of plaintiffs, one whose behavior is impacted by the new laws and rule changes, and one who is not, we use a difference in differences methodology. This is an econometrics methodology where one group is considered treated and the other is untreated, the control group. So here, the treatment is the rule or the legislative change. And the external event, the change, is that implementation. And the treatment group is the third-party debt collectors in all 3 states. The control group are the original creditors. So we compare the relative differences across a number of variables between the 2 groups, the control group and the treatment group, over time. We look at outcome variables, and we evaluated the differences in the rates of things we thought would be affected by the treatment to the law or the rule change. And we controlled for individual differences within the creditor groups using fixed effects. So various other things happened with regulation or national enforcement that affected certain high volume creditors, but not others. So we used fixed effects to control for that. So as shown here in this example, here the x-axis is time and the y-axis shows the difference between filing rates between the treatment and the control group in Texas. After the event, the rule change is shown by the dashed line. There's no change really in the trend in filing rates for third-party collectors as compared to original creditors in Texas. So as you can see, the difference in the filing rates between the treatment and the control groups stays quite close to the 0 line. There's not a change in the trend in the differences in filing rates as a causal effect of the event. So the shaded spaces show the standard errors. So the results are within the error range, and where we see it stays close to the 0 line, that really shows no statistically significant difference between the treatment and the control groups. So let's look at the same variables in Connecticut. Unlike in Texas, in Connecticut, debt documentation reforms did affect case filing rates by an average of about 10 cases per quarter, fewer cases filed by third-party collectors compared to original creditors after the rule change. So there's no evidence really of a pre-existing trend in this difference before 2014, which allows us to interpret the result as a causal effect for the new Superior Court rule. A pre-existing trend prior to the date of the rule change would show us that the behavior of third-party debt collectors was trending in a particular direction prior to the event studied. So in Connecticut, the parallel trends assumption is not violated. We see no pre-existing trend before 2014, and we can interpret a causal relationship following the rule change. So shortly after the rule went into effect in Connecticut, third-party plaintiffs started filing cases at a relatively slower pace than original creditors. And this relative decline in third-party filings continued for several years, reaching its largest magnitude by the end of 2020. So let's turn to California for a minute. This chart shows a different variable, not filing rates, but default judgment rates. So a default judgment is entered against a consumer who does not show up, who does not respond to the lawsuit. In California, responding to the lawsuit requires paying a filing fee and filing an answer. So the rate of consumer engagement is incredibly low in California. Only about 10% of consumers participate in the debt collection lawsuit. So one of the things we wanted to study here was, did the debt documentation reforms make a difference in really the number of cases that were rejected by the courts for filing? One of the changes in the California Fair Debt Buying Practices Act, this legislative change, transfers responsibility for the entry of default judgment from the clerk to the judge, in addition to requiring additional documents for third-party debt buyers. And this did have a pretty dramatic and immediate effect on default judgment rates for these plaintiffs compared to original creditors. Over the study period, debt buyers were 7 percentage points less likely than original creditors to obtain a default judgment after the California Fair Debt Buying Practices Act went into effect. The CFDPPA also increased the time to judgment by about 10 weeks. That's reported in the full policy report. So this shows a causal effect that imposing debt documentation requirements and then actually asking a judge to look at that paperwork reduces the number of cases that end in default judgment, even though filing rates were about the same in California. In California, there was also a mandatory form for default judgment that debt buyers, and that was implemented on January 1st, 2018. So actually, we see a bit of a reduction in the difference in default judgments between the treatment and control group around that date. This may indicate better compliance with the documentation requirements once third-party debt buyers had really a checklist and a form to fill out, and they needed to sign affirming that all the documentation requirements are met and the documentation is attached. So we also looked at the value of cases across 3 states. We hypothesized that debt buyers would file fewer low-dollar cases because they didn't have documentation, that the cost, right, the economic cost of obtaining documentation would not be worth the value of the case, and that those might be thrown out or disposed of rather than filed. But we really didn't find that in any state. We expected to see an impact in the amounts in controversy because we expected debt buyers to file fewer low-dollar claims that are missing documentation. So this chart shows that prior to the rule change in Texas, debt buyer cases were on average about $500 more than the original creditor cases, but the difference in the case values was already trending down. So we have a violation of the parallel trends assumption that we had a pre-existing trend that was trending down. So after the rule change, the cases were about the same value. As you can see, the difference in case values is close to the 0 line and within the range of error. This shows that we did not find a statistically significant causal relationship between debt documentation requirements and amounts in controversy. We also didn't find a statistically significant relationship between case values and the event, the legislative and policy change in the other states, California and Connecticut. So this raises questions about compliance with the laws and the court rules. Because we expected these laws to really affect the values and so only the meritorious higher value claims were being filed. This was surprising, and it raises questions about compliance, or if debt collectors are manufacturing documentation, right? Are they just filling out an affidavit saying that they have those documents, but they don't actually have them? So we decided to look at the actual documents filed in cases. We examined the relationship between the creditors and debt buyers, and we looked at the affidavits attached to requests for entry of default and supporting documents. So Connecticut requires that an actual contract be attached for a third-party debt buyer to file an request for entry of default. However, among 88 random cases that we examined, and we looked at all the documents and we tracked and coded all the documents in the case, we only found 1 case that actually had a document attached to it. There's also a requirement that they declare in the affidavit that this is within the statute of limitations. Of the 88 cases we examined, not a single affidavit met the requirement to include a statement about the statute of limitations, right? So for the academic papers that are coming out of this work, we're replicating this in California. So up here is an example of where this is just left blank. The affidavit has the information section in it, but it does not have the actual date on which the contract was allegedly breached, therefore making this within the statute of limitations. So what are our takeaways here? Judicial rules and legislation to regulate the behavior of debt buyers are steps in the right direction, but these efforts need to go further. We need comprehensive monitoring and evaluation. We propose that courts should consider implementing small random audits to review compliance. We need stricter enforcement mechanisms. Courts should implement rigorous verification processes, and there should be penalties for repeated non-compliance to deter lawsuits that are not filed in compliance. We think the implementation of these rules should include training checklists. Zach Zarnow from the National Center for State Courts walked us through a tool that they created to create checklists for judges. We also think that courts should fix past mistakes. In Connecticut alone, thousands of judgments may have been issued in cases where the plaintiff failed to comply with the rules. It's difficult and maybe procedurally impossible to set aside all of those judgments. But our recommendation is that upon application for writ of execution, when the creditor seeks to enforce on that judgment, that the judge should review the case file for compliance. And if a court is erroneously granted a judgment, the court should not issue a writ of execution. So thank you so much. Please email me. Oops, I've lost. There we go. Please email me with any questions. And please do check out these papers and our other work at debtcollectionlab.org/research. Thank you.
Thank you very much, Claire, for your paper. Our next speaker is Danielle Kalil, who's the Director of Civil Justice and the Judiciary at the IALF.
Yes, and if it's okay, I'm going to stay seated. I have a broken toe, so I think it would take about half my allotted time to get up to the podium.
Go for it.
If you could pass the clicker, though, that would be very helpful. So my name is Danielle. I work at IALS, the Institute for the Advancement of the American Legal System in the United States. IALS is an independent think tank research institute that innovates and advances evidence-based solutions to make the U.S. civil justice system more just. So a cornerstone of our work is bringing about an accessible system that meets the needs of users. But of course, before we can do that, we need to understand what those needs are and the level of access that people are currently experiencing. I realize I am preaching to the choir in a room full of researchers about that, but just want to give a sense of sort of what our mission is as an organization. So in recent years, IALS published what we call the U.S. Justice Needs and Satisfaction Report. This was a sweeping survey of 10,000 Americans about their legal needs and their experiences with the justice system. The goal of that study was really to help inform our national understanding of the justice journeys of Americans across income levels, across the country, across lots of demographic characteristics. What legal issues do they experience? What were the processes that they used for resolving those legal issues? What were their perceptions of those processes and the fairness of those processes? Were their legal issues resolved? If so, how were they resolved? If not, why? And who did they turn to for help? So that 10,000 participant survey has been published already. You can read it on the IALS website. But a takeaway from that study is that while low-income Americans are, as we all know, particularly a vulnerable population, the need for fairer resolution of legal problems was experienced universally across different income groups. So we turned then to a deeper dive into the data to better understand the legal needs of a couple specific populations that have come up many times throughout this conference. The first is the middle class, or people who are living at middle income levels, and those living in rural communities. So we're working on a couple of sort of focused reports on data, sort of pulling out those populations and looking at their legal needs and experiences. So today I'm going to be focused on the first of those, the middle class data. So the goal of this study is to really bring data to this discussion around the middle class. There's a lot of speculation in the United States about the legal needs of the middle class, but there's not a lot of data out there. So we have, a lot of access to justice conversations, I think rightly and appropriately focus on low income populations. But we know anecdotally and also from the data in the study that we did that those in the middle class often experience challenges accessing legal help and resolving their legal issues. And so we wanted to put numbers behind those stories. So what I'm going to talk about really focuses on what are the legal needs and experiences of middle income folks, and then how do those differ or align with the legal needs and experiences of other income groups. And through this data, we hope to really better understand if there are legal needs or experiences specific to the middle class that merit tailored solutions for that population. So we're working on our report, working with my colleague Courtney, who's right there on publishing a report about this. So I'm going to talk through sort of very high level data today. A few key takeaways in the time that I have. The report will be much more detailed and will be issued in the coming months. So this is how we defined middle class: 2/3 to 2 times median household income. Obviously, median household income is dependent on the year and the household size. All of that was factored in. And so we pulled out survey responses from those 10,000 surveys for folks meeting this criteria. And it amounted to about 50% of our respondents, which is consistent with other data that we have in the United States about middle income population. So much of what you'll see today is split into 3 groups: below middle income, and above middle income. It's kind of hard to talk about middle income in a vacuum without sort of comparing it to the other income groups. So we'll provide comparisons throughout. So first is, what are the issues? Folks were asked to review a list of issues and identify all that they had personally experienced within the last 4 years. So this is for middle class, the 5 most common issues that they experienced. This is similar to top 5 issues for below middle income and above middle income groups. Below middle income had money related in the top 5 instead of traffic, and above middle income had these same top 5, but in a slightly different order of prevalence. We also asked, of the issues you experienced, which was the most serious? And these were the top 5 most serious issues that folks identified. Same top 5 as the below middle income group, but in a slightly different order. Middle income folks were much more likely to experience an auto accident as a serious issue than other income levels. And above middle income had largely these same top 5, except in place of emotional abuse, had physical, sexual, or mental harassment at work as a top 5 issue. So we also asked them to rate sort of the seriousness of the most serious issue. And this is where we start to diverge more between the middle income group and the below middle income group. The prevalence of legal issues we found was roughly the same across income levels, but the seriousness was not. So you can see that as income level decreases, seriousness increases. And I think that that's not terribly surprising given what we know about safety nets and things like that. So the next set of slides is about resolution. Were the issues resolved, and was the resolution fair? So we asked about, and in this section, the middle income group was more aligned with the above middle income group when it came to resolution. So similar prevalence to below middle income, but experienced resolution at a slightly higher rate. So this was in response to, which describes the current status of your issue: completely resolved, resolution expected in the future, or no resolution expected in the future. And here you'll see middle income roughly aligned with the above middle income group. Note though that still only about half of the issues were resolved, right? Which is, consistent with our broader study, what we found. In addition to asking about resolution of all issues, we asked about resolution of the most serious issue, and specifically, how was your most serious issue resolved? By far, the most common response was that folks solved the issues with their own actions, so outside the legal system. 27.2% of middle income respondents reported solving the issue with their own actions. And this was true across income levels. Across income levels is almost 30% of people responded that they resolved the issue with their own actions. And then I realize the text here is really tiny, I apologize, but there's also the other responses are sort of listed in there. Okay, and then we asked about resolution fairness. And this is where middle income respondents were actually slightly higher than either other income group to perceive the resolution of their issue as fair, with 61% responding that it was fair or very fair, compared to 56.7% for below middle income and 58.2% for above middle income. We also had a series of questions about, where are you getting help? Where are you getting help, and where are you getting information? So this is sort of actual sources of help, people who had an actual legal issue in the middle income group, where they sought out legal assistance for that issue. Lawyer was the most common, but only 22.7% of folks used a lawyer when they had a legal issue. And then you can see the other responses in there. So the below middle income group, lawyer was not the top response, family member was the top response, but they actually used lawyers at the same rate, about 22%. So below middle income and above middle income are both were using lawyers at about a 22% rate. And then the above middle income group used lawyers at a slightly higher rate, 26.2%. So we also asked for respondents who had not yet experienced a legal issue, how likely would they be to ask a lawyer for information or advice? And here I find this interesting because there's a large mismatch between the 22% that actually used a lawyer and the folks who said that they in the future believed that they would use a lawyer, which is, I believe, 88%. So about 88% said they believed they would access a lawyer for information or advice, but in reality, only 22% did. And the likelihood of asking a lawyer, you could see, jumps a bit with each income bracket. We also asked how likely is it you would be able to afford help to resolve a legal issue. Nothing surprising here, right? It definitely correlates to income level. And then finally, we asked if you were involved in a legal dispute, would you know the steps to take to resolve it? The above middle income group here was the only group that was more likely to agree than disagree with this statement. Middle income group here is more aligned with the below middle income group and more likely to disagree that they would know the steps to take to resolve it. And then we have some questions related to sort of the procedural fairness feelings around the process, stress related to the process. To what degree did you experience stress resolving this was about their most serious issue. And the higher income levels here actually reported a higher degree of stress related to the process. And same is true for negative emotions related to the process. So that is just like a very quick and dirty high level overview of the data. There'll be a much deeper dive in the report and drilling down on sort of these questions and many more that were asked. But I think this data really calls for an expansive approach to the access to justice crisis that encompasses the needs of the middle class as well. And one way that ILS is working on addressing that is through our Above the Line Network project, which I'm happy to talk to folks about more offline. But this is a project aimed at addressing the gap in access to affordable legal help for those who don't qualify for legal aid, but for whom the traditional legal market is largely out of reach. I myself as a lawyer probably could not afford a lawyer, right? And so this project is aimed at sort of getting all of the resources and folks together in the same room working on this issue to put their heads together and scale solutions for this population. So that's all I got.
Thank you very much, Danielle. Our next speaker is Erin Turner, who's the CEO of the Consumer Policy Research Center.
Thank you so much for having me. So my name's Erin. I work at the Consumer Policy Research Center, and we're an independent think tank. We're a charity in Australia. We measure our success by how our work influences reform. So ultimately, we're researching and understanding problems, but we want our research to change business practices, change regulations, or change laws. I'm going to be running you through two different pieces of research from CPRC in the last year. I'm going to go at a cracking pace to get through this. So if you'd like the slides afterwards, please ask me, and you can access both of these reports at cprc.org.au. Essentially, I wanted to bring forward themes that answer the question, what stops people from using their rights, from trying to access justice with a specific consumer problem? And I'm drawing on research into how people experience faulty car issues in Victoria, Australia. That was a multi-methodology survey, only possible because of a fantastic partnership with Consumer Action Law Centre and a couple of other community legal centres. And then a deep dive into telecommunications problems, which we did in partnership with the External Dispute Ombudsman for that sector. So I'm going to start with the telco stuff. In putting these two aside, I think there's different lessons we can learn from each of them. And the big narrative here with the telecommunications sector is that initial contact with businesses, which is the first step someone takes in going to get a resolution, really matters. The quality of customer service really affects basically how likely someone is to re-engage with a complaint and how likely they are to progress with a complaint. Key takeaway from this slide, telecommunications challenges are common. Almost everyone had one. But what's really interesting is that the issues that are common, reliability, quality, network dropouts, they're not the things that people say actually impact their lives. The things that people say impact their lives are when telecommunications companies fail to follow through, when they said they'd fix something, but they didn't, when they take a long time, or when you can't even contact the telecommunications company in the first place. This quote from our survey, it came through again and again and again, and I think it really captures what people are experiencing. This person had a problem, they had rights, they couldn't even contact their telecommunications company initially. They spent 8.5 hours over 5 or 6 days just going back and forward in that first step of the resolution process. And for people not from Australia, the resolution process here is you have a problem with your telco, you contact your provider. If they don't help you, you can go to external dispute resolution, the telecommunications industry ombudsman, where decisions are binding on the telco, independent, fair, great system. You've got the option to go to the courts if you need to. We found that very few people actually just went through that first hurdle of making a complaint. 54% made a complaint, and nearly a third, 29%, even though they had a serious issue, still didn't make a complaint. Why? They didn't trust the process, or they were overwhelmed. 40% of people said they didn't think their complaint would make a difference. 20% didn't even know where to start, and they said the process was overwhelming. This is one that I am really worried about, even though we have a free independent ombuds service, that when we looked at the small cohort of people who used it, they said, yes, the TIO was great. They worked with me. They were really satisfied with that process. But only 10% of people who have a problem with their telco make it to the TIO. And that number actually drops for people with a serious issue to about 7%. So people just aren't going all the way through. This comment is actually a really interesting one. I've pulled it out because it's from someone who had previously gone to the ombudsman, but then had another issue and chose not to. He found the ombudsman work really well, thought he could get a great outcome, but the time, mental bandwidth, and patience required to engage in that process stopped him from going back. I'm going to end on the telco stuff here in this slide. These are comments. We asked people, well, what would have helped you make a complaint? For some people, it was process. If it was clearer, if it didn't take as long, if it didn't take them 8.5 hours just to get in contact with their telco company, if it was streamlined, and knowledge of the process. A lot of people made this mental distinction between contacting their company and formally making a complaint, thinking it was something different, even though technically it wouldn't. So there's this interesting distinction there. And then this idea of penalty. People were angry, and I think quite rightly so, but they wanted to know that if they made a complaint, something would happen to that company as a result, or they would get a benefit. They were doing the cost benefits in their head, and based on the time they thought it would take them and how difficult the process would be, they made the assessment that it wasn't worth it for them. Overall, I think there's this underlying theme of trust. People have had a terrible time trying to contact their telco before, and it's stopping them going back and using a system, even though that system is free, and if people go through there, they're relatively happy. I'm going to contrast this now with car complaints. I think there are trust issues. There's definitely quality of service issues, but there's something more fundamentally broken when it comes to making a complaint about a car problem in Australia. It's a systems problem, not a trust and customer service problem, or not just a trust and customer service problem. So faulty cars, they're really common in Australia. We looked at this in so many different ways. We did interviews with people who'd gone through the system, cases from First Nations clients, a survey of 1,000 people who'd bought either a new or a used car in the last 5 years. And what we found is that people bought cars and they frequently broke. In fact, 36% of people had a fault within 3 months. And under Australian law, you should have a remedy in that period of time, even for a used car. The remedy process is go to the dealer or go to the place that you have purchased it first. You have slightly different rights if you bought it through a private seller. We focused a little less on that. And then you can go through the Victorian Civil and Administrative Tribunal, which is meant to be a more accessible version than a court. We will get to what that practically looks like. For anyone who works with people on front lines, you know this. Faulty cars cause significant impacts on people's lives. When we asked people who had a problem with their car, whether it was small or large, so something that made it a little hard to drive or something where you couldn't drive it at all, 55% of people said they had non-financial impacts because of that issue. They had to miss work, they couldn't get their kids to school, they missed doctor's appointments. And I've included a case study here collected through the Victorian Aboriginal Legal Service and their partnership with Consumer Action Law Centre. And it just shows kind of the domino effect that can happen when you have a car break in your life. Christy is a single mother living in regional Victoria. Name's been changed for privacy. She experienced family violence, and a car was really critical for her in accessing help and getting out of that situation. But when her car completely stopped working, her family situation became more unsafe. There was a series of things that happened, the full case studies and the research, but she was forced to leave the state and her children were moved to foster care. She also lost her employment as a support worker. So that car just had this huge domino effect on her life. Now, you can't read this, but this is deliberate, I promise. We worked with community legal centres, practitioners, and people who'd gone through the system to map out every single step that someone would need to take if they had a faulty car complaint, from recognizing, oh, there's a problem with my car, taking it to the dealer, going through the tribunal process and getting an order. Every step from there to there, assuming it's a straightforward case, which they often aren't, 60 steps. And what community legal practitioners were increasingly finding is that it was taking years. 2 years is the common time that people are telling us at the moment. The length of that process is inaccessible for so many people. This is the big finding. There are a group of Victorians who simply cannot afford to complain. They cannot even start the process. That's a quote from someone we interviewed, and it's really stayed with me. The affordability reasons, there's a few things. First is the cost of towing. If your car breaks down, even before you can start figuring out if you have a legal problem and get your rights, you've got to tow it somewhere and you have to pay for that towing. You maybe might be able to get some reimbursement for it down the track, but if you're on a low income, that's not feasible. And there's multiple points in the complaints process where you likely have to tow that car, not just back to your house, but say to a mechanic to assess it or to gather evidence. 22% of people who didn't progress with a complaint didn't do so because they just couldn't afford that towing cost. Kind of similarly, the tribunal process requires that people keep the car. That's evidence. So for a 2-year complaint process or longer, you have to hold on to this car, which you likely have debt on, or you just have debt generally in your life. 14% of people had to sell their car. It was repossessed, they couldn't do it. And there's a range of other related debt collection issues, debt collectors, bankruptcy issues. These are the people that are falling out of the system because they cannot afford to complain. It's not about the fees at the tribunal process, it's about the cost to them holistically of this complaint. If you make it to the tribunal, it is long, it is confusing, it is expensive. This came through in the survey data, it came through in the interviews, it came through in the work we did with legal professionals who are using this system every day. 97% of people who took a complaint about a faulty car to VCAT needed some support from family, friends, legal services, whether that was community or they paid for it out of pocket. This is not an accessible system. The expert report also really stood out. So in the Victorian system, if you're taking a car complaint, they actually have a very specific form. It's given a weird title with some numbers. It is very intimidating. It's legalistic. It asks you for some very specific things, and it has to be completed by a mechanic in a certain way. Now, this form is so complex that only some mechanics will offer to do this service. And quite often they specialize in certain kinds of cars. So there'll be some that might specialize in high-end cars, but it can be harder to get them to write a report for more affordable entry-level used cars. 93% of people hit a hurdle when they tried to get an expert report done. The report was unaffordable. They couldn't tow their car again to get to that expert. That really hit for people in regional areas. They couldn't even find an independent mechanic. Or, coming back to that cost issue, they didn't have the vehicle. And again, working with community legal practitioners, this was an issue not just for self-represented clients, this is an issue for community lawyers too. Here are some of the reasons why people don't use VCAT. The comment in the corner is actually, I think, captures so much of it. There was just a lot of technical, like mechanical things that they wanted, and I didn't really know what that was. The process currently expects you to be an expert in the car. It expects you to be an expert in the law as well. People running these complaints are experts in their own experience and in their lives, but they're being asked to do so much to navigate what should be a much more accessible process. There's also a group of people who just didn't even know they could go to VCAT or didn't think their case was strong enough. And for me, that's an intimidation factor. Last slide here. This is Xavier's story. So again, this came through the partnership between Victorian Aboriginal Legal Service and Consumer Action. Xavier is a First Nations man in regional Victoria. He purchased a used car from a dealer for $14,000, got an extended warranty and a loan, got the whole package. It was quite expensive. Within 3 months, the car had a major fault. Basically, the full engine needed replaced. And that meant he had rights, not just under the consumer law, but also under a state statutory warranty scheme. So it should have been a really straightforward case where the car got fixed or he got his money back. Consumer Action Law Centre was in his corner from an early point. They were there, they were backing him. So this is kind of the best case scenario for someone like Xavier. They struggled. The car dealership just didn't engage. And it really shows that there's some dealerships that are used to playing this system. They drag out every step of the process. They know that people will fall out. And the worst that's going to happen to them, typically under a legal system, is that they're going to have to do the repair they should have anyway after a long and lengthy process. Maybe there's a little bit of compensation, but it's very minor. So they dragged out the complaint process. They ran it all the way through the tribunal system. They nearly got to the end and then the dealer settled. They knew that this was an obvious case. Xavier got a little bit of compensation. I think it was a few thousand, and the repair he should have got 2 years ago. But he incurred so many costs in those 2 years. Just basic costs of getting from A to B in an area with very little public transport, and still having to deal with his extended warranty, his loan, all the other costs tied to this car. Consumer Action costed out, this was obviously free to Xavier. They costed out what would it take for them to run this case if they costed it. It was $33,000 just in legal costs alone. That's before you even consider the costs to the tribunal and to the government of this case, the cost to Xavier himself, but just putting that $33,000 in legal costs to resolve a $14,000 legal problem. This isn't working. This system is stuck. And putting this next to the TIO, I think there's some really interesting lessons to learn here around accessibility. I'd love to get to a point where in the car dealership space, we're talking about, oh, customer service isn't very good. It's still a problem and it's still genuine and we want to deal with it. But before we even get there, we need to look at the length of the process and how do we mitigate the costs that people experience around making a complaint. That's it.
Thank you. Thank you very much, Erin. You're giving me flashbacks to when I purchased a terrible car in Australia when I was 18 years old. So our final speaker today is Juliet Uraz, who's a PhD candidate at the LSE and a visiting research fellow at Harvard.
So I'm going to tell you, sorry, can you hear me now? I'm going to tell you a story about the other side of the Atlantic. It's a fairly tragic one, and the header is like people die and get evicted. So if you need to remember one thing about this talk, it's this. But just as it's preliminary results, so don't rely too heavily on the numbers, okay? So in case you're thinking about eviction in the US, we have heard a lot about the eviction pandemic. Well, if you decide to move to the Brexit countries, the same is happening there. It's just not making headlines. Okay, so this is more for creating some trauma if anyone was thinking about moving. And then we know from like the legal needs survey that even if not everyone receives legal help, this is like the most recent one in the UK, about half of people still will receive some sort of professional help, as much as you do when you get evicted from the White House. So what policymakers do now, right? What is the other side of the story? What can you do if you really want to do something about evictions? Well, we have two types of stories that have been happening: right to counsel in the US and some local initiatives in the UK. So this is a picture from the Mayor of London, where we would boost cash for service that fights eviction, no matter what the service is actually, or it doesn't mean that this is legal assistance, right? Why am I showing you this? It's because of the economist hat that I would like to convince here. So let's say that you have to convince an economist of why he should look like at legal assistance. Well, he would say that the state has to intervene, or we need policy intervention if some conditions are met, right? One of those is going to be a welfare condition. And we could frame it as, is the social cost of not resolving the legal problem or actually higher than if we were subsidizing legal assistance? Another way to think about this is this market failure where the supply is not meeting the demand being the legal needs, and the supply being the provision of legal assistance, which is affordable and accessible for everyone. So now, if you think from the policymaker perspective, it's like, do we really need to invest more public funds in civil legal assistance scheme, but also for which type of scheme, right? So we have all this call for robust data evidence. I don't need to convince you, but then it translates into this type of cost-benefit analysis. And the response here is like, what can we actually do with the data we have? So we can look at the impacts of changes in provision. So either introducing more provision or removing provision in different contexts. But here you have to think about either we just look at access to justice itself, or we go one step further, which will be welfare broadly defined. And then, there's this research agenda of what works for whom, but also to what extent does public provision really matter? How can we measure it with something that will be quantifiable and that we could communicate to some government officials? So what I'm going to show you today is basically focusing on a reform that happened in the UK almost 10 years ago, austerity-driven, where they removed public funding for legal aid, specifically for social welfare cases. And so lots of metrics, econometrics behind this. I'm happy to talk about this off the call, but I've removed all the methodology here. What we're doing is just using the spatial and overtime variation that was triggered by the interruption of legal aid services. So it was unintended consequences of the reform. And we're looking at the effects on eviction. So eviction actually go up, but also debt, housing market, and mortality. I'm only going to talk about eviction and mortality today, but just for you to know, this is coming up. So a bit of the context. Legal aid in the UK is a funding mechanism which is targeting the low-income people. The threshold have gone lower and lower over the years, just giving you some numbers here. But what's interesting is delivered by lawyers who have some sort of public procurement contract with the Ministry of Justice. So the lawyers can be sitting either in private firms or in not-for-profit organization. And sometimes this not-for-profit organization are going to do both legal aid, but also pro bono work. And the cost, the scheme, is going to finance not only legal representation, but also some sort of legal advice. And depending on what type of legal problem you have, you may qualify for more or less of legal aid. And it's going to depend on the area of law, the complexity of the problem, but also more importantly here, at what stage of your legal journey you're in for actually being able to access a scheme. So what happens with this reform in 2012, 2013, it's had an impact both for the beneficiaries of legal aid, but also for the providers of legal aid. So both sides of the story, the demand and the supply, right? So for beneficiaries, the timing of that as a time at which you can actually access legal aid change. So before the reform, let's say, if you were getting a letter from your landlord threatening you to be evicted, you could still get some sort of front help desk advice. But we removed this funding and we shifted to what we define as a last resort scheme, where you need to formally be evicted, have received a formal eviction notice for being entitled to the program. And the scope of the scheme was also reduced, where on purpose, we excluded cases that did not pose what was said a direct threat to household health and housing security. So housing disrepair were left out, but eviction was kept, right? Or also most of public benefits decision were put outside of the scheme. So you end up in a situation where the number of legal aid cases just dropped massively. So you had like 400,000 on average before the reform. It's almost divided by 10 afterwards. It went way beyond expectation. And one of the explanations in the literature is that people actually thought that legal aid was not available at all anymore. So they self-selected themselves, didn't know when it will be available, not available. They just didn't ask for help. But this consequences, because of the way the system is structured in the UK, translated in a massive drop of funding for businesses that were not sustainable anymore. So the number of providers taking on legal aid cases also dramatically reduced, even if legal aid was still there for some cases. So this is a map basically showing you just on the aftermath of the reform, places in dark blue, where you had 100% decrease in the number of providers. For most areas, that meant that you didn't have any legal aid providers left. And if you're in green, it means that you didn't have a change. If you look over 10 years, you basically have almost no legal aid providers left in rural areas or in the poorest areas of the country. So the type of data I'm looking at here, and this is mostly publicly available data, so we can reproduce this type of study in other contexts. It's using the directory of legal aid providers from the Ministry of Justice perspective. So we're going to look at who is doing legal aid work over time, around over 14 years, and just look at who is opening new cases. And then on the outcome side, what is the impact on X? We will take court outcomes, so how many eviction claims, how many eviction orders, same for the small money debt claims. but also mortality data, because that's the great thing about death is actually available. And you also have housing market indicators that you can look at the community level, because all of this story, if we go back to the map, is about to what extent in your area more or less affected by this reform. Do you still have a legal aid provider left in your area, or you don't have any? So many of this outcome are actually available at small area level. You don't need to have them at the individual level. So the results, let's say 3 main spotlights. The motivation of the reform was to discourage unnecessary litigation, with this idea that actually we could settle things outside of court. So what I'm showing you here in this graph is like, in red is what is happening before the reform, in blue are the different time periods in the 10 years after the reform. You have this increase, linear increase in the number of eviction in the areas where there is less legal assistance compared to areas which were the least affected, where there's still some legal assistance left. So it's a bit weird, right? Like it looks like a wave, but actually that's a pandemic. So all up till the pandemic, you have this linear increase. At the time of the pandemic, you have eviction moratorium, backlog of cases. So the difference between the most affected and the least affected areas diminish and cancel out. And when you're after the pandemic, which is the last available point, you're actually back to the same level. So even 10 years afterwards, the effect of the reform is still really important. And if you were trying to translate this into some numbers, so again, take them with caution, that would be about 50,000 additional claims compared to before the reform. So that was a number of claims. If you look at eviction orders, and here the idea that actually maybe doing it yourself is as effective, you don't need a lawyer to represent you. So, you could still figure things out, even if you don't get legal representation. Well, the number of orders also went up. So the impact is smaller in terms of amplitude, but you have the exact same pattern, right? The same wave disappearing during the pandemic, back to normal after the pandemic. And that would be about 20,000, between 15 and 20,000 additional orders, which could be linked to either you access legal representation too late in the process, or you just don't access legal representation at all. So now the other one, which I think can be potentially the most interesting, is the mortality story. So what is happening in your area in terms of aggregated mortality? Here it's showing you the data excluding the pandemic, but you do have some sort of linear trends, which would suggest that the mortality in the most affected area is higher after the reform, and it keeps, the difference keeps increasing over time. So it's a coincidence that the number is the same as the eviction, like that would be an additional 50,000 deaths. Do take this with a lot of caution. This is like a rough number. So most likely it's maybe like half of this when you control for everything else, but there's still something going on, right, in terms of mortality. And then the economists will be like, but why? Why do people die? It's not because they get evicted, right? It's not like they all end up homeless and they die in the street. Well, we know that the number of people who were evicted or just like a really small proxy of the total number of people who actually face housing insecurity. So this is like the lowest possible estimate that we have, because most eviction actually happen even before ending up in any type of eviction claims or eviction orders. But at the same time, you also end up with a higher number of households who navigate the legal journey alone. So a higher level of stress, and I think that has been pretty well documented in the previous session, health and access to justice. We do know that stress-generated illness over 10 years could result in like a shorter lifespan, right? But at the same time, and that's maybe the key point I would like you to think of, is if you reduce legal assistance in an entire area, you also increase the number of households that do not receive what we would call holistic assistance, right? Not just about dealing with your eviction issue, but everything else going on in your life. And if you go back to the Singbird, when he gets eviction notice, most likely there are other things going on that could explain why he's facing an eviction in the first place. So it might be a loss of income, it can be a sudden illness, it can be a break in the relationship. And all of these different issues actually translate in lots of different legal problems, where the eviction proceeding is the one on the top of your list, and the only one for which you can get legal aid in the UK now, but you still need to fix all of the different things. So, we know this clustering of legal problem. We also know it correlates with the clustering of vulnerabilities. And that's where lawyers don't do just housing law advice when they deal with eviction, but they might just signpost you to healthcare providers or identify a disability or mental health problem, which usually is going to help your case as well, right? Because you can adjourn the case based on mental health issues. but that could eventually lead to higher mortality down the line if this is not done. They might also check how to maximize your income, checking if there's any type of public benefit you're eligible for, but not getting. So in terms of conclusion, I think this is trying to call for not just looking at impacts on access to justice outcome, but going to welfare measures, thinking about it as like a multidimensional process, like this domino type of effect, but also how it can accumulate over time, and how we could better explore the interconnectedness between access to justice and what I would call access to the safety net. So this holistic type of assistance, which can be done by community justice worker, where you're just going to signpost your client, or done by yourself as a lawyer. Yeah, we need more data, but this, I will keep saying it. So thank you.
Thank you, Juliet, and thank you to all the panelists for some really wonderful papers. We now have some time for questions. So does anyone have any questions? No one has any questions. Well, I'm sure I can come up with some questions. So I'm interested in the matter of getting access to data, and I was wondering if panelists who are interested might comment on some of the challenges that they've encountered in terms of getting access to data, and what we might be able to do kind of collectively to push institutions to give us the kind of data that we need to do some of the really interesting work that you folks have been doing. Anyone want to take that on? And I think you can stay seated. If you
I'm
want.
happy to jump. I don't know if this is on.
I think it is on.
It is on. Okay, great. So, so in the United States, access to civil data in state courts is really, really a big challenge. So that's actually one of the reasons that the Debt Collection Lab came into existence, because there were a number of scholars working sort of in silos in individual states, and we realized we needed to get together and get data standards. We're also working with the Legal Services Corporation and with Professor Titina Rostein at Georgetown, who was here speaking yesterday about the Georgetown Data Commons. So there are efforts underway to bring researchers together. However, most of that data is still collected through either scraping court websites. And again, like California has 58 counties, Illinois has 102. Those are 102 in Illinois, where I live, 102 different websites that we would need to scrape. And most of them have CAPTCHAs that actually get in the way of our web scrapers. So the other way in which we collect data is through data use agreements with courts. But here, and as I mentioned, the example of Illinois, we're actually in conversation with 80 different chief justices, as well as with some of the case management systems about collecting that data. So that's time intensive, that's resource intensive, and it requires sort of a level of diplomacy because we needed to get a letter from the Supreme Court, and we needed to get a letter from the Access to Justice Commission, and things like that. So even when stakeholders are on board with the sharing of data with academic institutions that can engage in cleaning, normalization, and implementation of data standards so that we can compare variables across jurisdictions, it's really time intensive. So I would say it's almost insurmountable to say we should change the back end, that we should have standardized or unified case management systems, because that's cost prohibitive. And so I think one of the ways that we can really work toward data collection and data normalization is by convincing the holders of the data that they don't have to do anything with it for us. Just give it to us and we'll engage in the normalization. So we're hoping that through projects like the Debt Collection Lab, that we raise the profile of academics who are doing this work, and that we don't ask the courts to do the work of organizing that information. They just hand it over to us, and that we can then work to normalize it. However, that's still a bit of a challenge.
Anyone else?
Yeah, actually, at risk of overloading, there's a third report, and we actually talked just about this at CPRC. We released something about a month ago called Am I the Only One? And it looks at, I think, a really interesting data source that some states in Australia are taking advantage of, but not many. And that's consumer inquiries about their legal rights to regulators. Depending on the regulator at a state level or at a federal level, there can be hundreds of thousands of these inquiries a year. And it gives you a really good sense of kind of the early stage of the process before someone even makes it to a tribunal or a court. What are the problems that they're experiencing? Now, 2 states in Australia, Queensland and New South Wales, publish some form of data around this beyond just like a raw headline number in an annual report. New South Wales actually has this beautiful monthly data release where they name any business that's had 10 or more consumer complaints. They talk about the issue and kind of the nature of that. And so you can get a really good sense of the problems over time. And they're using it to regulate sectors and name and shame and push businesses to do better. So we're trying to very actively get other states and territories to follow that lead. And tribunals also have a real role to play here. We tried to work with VCAT to get data around cars. I'm seeing some Australians laugh at this. There were some very nice people who were working in tribunal who wanted to help, but they literally do not collect this data. They're seeing these problems as whack-a-mole. It's a single issue. So they're not collecting data around like, is it a used car or a new car, or is it involving a dealer? These are really essential things that are stopping us then understanding the nature of the problem and improving systems.
Any other thoughts by panelists? And then I see some questions.
Yeah. Oh, go ahead.
Sorry.
Go ahead. I was just going to say, I agree with all of that. And one more note on the sort of qualitative side and asking people about their experiences with the legal system. That's a very vulnerable thing to do, to speak to a stranger essentially about, you know, some of the hardest things you have gone through. And so something that we are continually working on and working toward is, we are an unknown entity to many of these litigants. And so finding community partners who are trusted, who we can partner with, and you know, meeting people where they are at to sort of help close that gap a little bit and that yeah, make it less difficult to speak about those vulnerable things.
Maybe just like 3 short examples about this data thing. So the one way of doing this type of economist study is like you take what is available at the small area level, and then you don't need to get into any data governance about sharing sensitive information. So you might think this is easier, this should be straightforward. Well, you need both sides of the story, right? You need one side, which is what is a change in provision. So where are providers actually located? Where are lawyers? Where are the courts? So I asked the Ministry of Justice in the UK, where are your courts and where were they 10 years from now around, right? Like there has been a lot of merging about courts. They didn't have a real estate list of the court. So they couldn't just like share the address of the court system, which is saying a lot about, we do not keep track in the justice sector about where things are right now, but also where things have been in the past. And so if you want any type of measure, you need to start tracking things. So that's one thing. And on the other side, you need the outcome, right? So you need to know, what are you looking the impact on? And in the US, I wanted to look at benefit take-up. So just get some administrative data on what is the level of benefit take-up. Doesn't matter what benefit you're thinking of, can be SNAP, it can be Medicare, Medicaid, at let's say the zip code level. I've asked a lot of different state agencies through a freedom of information request. None of them came back positive. This data is supposed to be really handy and easy to share. So there's in principle no reason why it wouldn't be easy to just like send an Excel file. But you know, we have also to overcome this type of barriers where we need to argue, well, this data is important just for showing the, you know, showcase the importance of legal assistance. And it goes beyond the court, right? Like both of them are actually not just about the court dealing with their own system. So that's other doors we could knock at. But if you go at the individual level, you can also merge administrative data with providers' data. So we have one project in the UK where we collaborate with one local authority and one law center. So obviously it's not many people, right? About 150 people in our sample, but we get information from the local authority, which tell us who is getting what type of benefits all the time. And we get legal information about the legal problem from the law center. So this type of collaboration takes ages to put in place in practice, but it can also help us to just go beyond whatever data we have from the legal side. So
And I'll just second the value of like person level data or case level data, because a freedom of information request will often come back with like aggregate data, right? X number of cases filed per year in this county. And that's not nearly as helpful as getting the underlying variables that are kept within that data source at the case level or at the person level, and the value of combining data sets.
Great. There was a question here. You'll need to come up and grab one of these mics.
Slightly different question, and I really appreciate it.
Is it going through?
Yeah. And I'm totally geeking out on the economics of this, the analysis of this. I'm loving it completely. My question though is around using this. So I guess when I think about this kind of work, I think this is a great way to engage with governments who are generally interested in cost-benefit analysis and all that kind of stuff. But my concern a little bit is that while intellectually we know that that's what governments should be interested in or tell us they are interested in, they often make decisions for a variety of reasons which are completely and utterly not related to the economics of what we're talking about, particularly I think with the client groups that we're talking about. And I'm just wondering any thoughts on how to translate what they're doing into actual change, and that process of how you actually take these fantastic, you will all say this is great, but how do we leverage that into actual change when policymakers are more or less engaged with this for our vulnerable groups?
Anyone want to take that on?
I feel like that was a Dorothy Dixit for me. In some ways, it's fantastic. So this is actually a lot of what my organization does. It's trying to think about where do debates need data to push a reform and where don't they? Because some debates, as you rightly point out, you're not going to get the change through, hey, here's a report where we've considered everything really thoroughly. It's a much more emotive debate. We find that there's a couple of different levels of decision makers that are really important for us to engage with. And we're getting more success the earlier we engage with them in the research process. So it's not like we drop a report, surprise, it's done. They want to see the media outcome of this, but particularly working with departments and bureaucrats early on so that they're then briefing their minister about how important this is very early on. And then when the media comes in, that reinforces it. That's been a really helpful thing. And then advisors, ministers, opposition. It's a lot of work. I often don't get funding for it. It's the thing we do as a cherry on top. I think every other community legal sector organization would be in a similar kind of situation here, but it's the stuff that gets it over the line. You need the data to have the conversation, but actually having the conversation is the thing that pushes it.
Well, and I'll just jump in at this evaluative project was actually solicited by the Pew Charitable Trust, which is our funder, and they sought researchers to evaluate whether or not these debt documentation reforms were actually making a difference in like the substantive outcomes for consumers. And so that then Pew, who works closely with state courts, could either make recommendations for additional debt documentation state laws or advise against them or advise that they should be constructed in a different way. So I will say, back to the access to data point, the data is really important for us to evaluate whether or not legislative changes are effective, despite the best intentions of the legislatures in implementing those changes.
I think there is a really cynical answer to this, which is how to convince them that it can be cost savings. And like, so either playing with the duality of the system where, okay, the local authority is actually interested in getting more federal money in their own area. So they want more people to claim benefits because it's not their own money that is involved, right? It's the federal money. So you can leverage a bit as different tensions, different regional level, I feel, for actually, if you get, I don't know, the city level or the local authority level being invested in seeing the value, they would push more money. And then the debate arrives as a central government because, you know, they have consequences. And so this income maximization perspective has actually been pushed by a lot of funders. So lots of community justice workers now have to justify to the funders, oh, we do have an impact, which is not just, you know, people are happy to be helped and feel heard and are empowered, but show us that there is an impact on their financial situation. So I think the income maximization story is one we can go to, but another one is also if we can find an impact on education, health, or things like this, it also puts the money not just about the Ministry of Justice has to fund this, but it can be Ministry of Health or Ministry of Education, or suddenly, you know, the Department of Finance is interested because it's multi-sectorial and it's not just the Ministry of Justice asking for more money. So it's
And there was a question over there. You'll need to come up here.
I'm just going to follow up on the comment about data sharing and sort of just add to Claire's really thoughtful things. So if that's okay. So in the United States,
You need to push the button, I think.
okay, I need to push buttons. So in the United States, for there's a huge problem with data being. There is a huge problem with data being captured with different systems. There's a problem with vendor capture. A number of you from the US might know of Tyler Technologies, which has created all sorts of systems where it's very difficult to get the data out of their systems. And the efforts to get data and normalize it and do it through data sharing agreements is fabulous. And the work that Debt Center is doing is fantastic. But it doesn't allow for creating a whole research community around using data, because if you get data under a data sharing agreement, you can't share it with other researchers, and you can't duplicate results, and you can't ask other questions of the data. Depending on what happens next, and so one other thing is going on is that the Office of Access to Justice in the United States is actually pushing administrative agencies in the federal government to move away from a data sharing agreement with each group, each researcher to a system where more people can share things. But depending on what happens next, if they exist after some point in November, it might be the occasion to sort of, for those of you working as it's to sort of push them on thinking about data sharing as something that's a really important thing, because courts are black boxes and you get bits. I mean, Claire has been knocking her head against this particular wall and is incredibly entrepreneurial about getting data, but the courts have become these black boxes and there's so much action going on in courts and getting it out of it. But going forward, there has to be systems where courts do use the same open data standards and collect data the same way, so that it makes it easier to do the research. So I just wanted to add that comment too. And you're welcome to comment on my comment. I don't need to be.
Any responses to any of that? It does make me think about what we can learn from other disciplines, maybe from medical disciplines, from health. There's been a lot of work trying to come up with mechanisms where researchers can share data in a way that addresses some of the privacy concerns that are particularly acute there, but that are also acute in the legal sector. Are there any other? Yep, you'll need to come up.
I think I know the answer to my question, but I'd like the benefit of your experience. When you're trying to help disadvantaged people navigate the difficulties of these various systems, how important are factors like legal capability and self-efficacy? Or can you just wind them up and push them through and it's all technical?
I can probably start on that. I think it depends on the system. So in Australia, we have, thankfully, a growing number of external dispute resolution services that sit outside of formal court processes. And for those, I'd say they are relatively more accessible. And there are more supports packed around someone who might be going through themselves. You can kind of point them and go to a degree. There is still a cohort of people that need representation and support, whether that's someone experiencing a mental health challenge or someone just who has a lot of other stuff going on in their lives. But there's this inherent tension then of, should an ombudsman service be referring people back to a community legal centre, because they have very few resources as well. So I'd say overall under-resourced. We need more of it. When you've got more complex systems, say the car example I ran through, 97% of people need some form of help to go through the tribunal process. I don't think that's something, you cannot educate your way out of that problem. You need to change the system.
Any other questions? No. Well, it is lunch is next on the agenda, so I think we will end there. I just want to thank the panelists again for a wonderful set of papers and for helping us geek out on some of the numbers. So Thank you very much, everyone.